Hi, and welcome back. You're watching Your Future, Your Finances. We're talking again with Eleanor Hunt, Esquire, a state attorney in the Maryland area. Welcome back.
Thank you, Brian.
We were talking about the three main documents last time, but there is also something referred to as a trust, a very complicated issue. It can be. Talk a little bit about that.
Yes, a trust is a written instrument wherein one or more individuals transfers legal ownership in property to a trustee, and the trustee holds that property for the benefit of one or more individuals, and they're called the beneficiaries. And trusts can have various characteristics. There are living trusts that can be created during your lifetime. There is a testamentary trust that can be created through your will, but it will only be established upon your death. There are also revocable trusts, so they can be revoked at any time during your life, and irrevocable trusts that cannot be revoked during your lifetime. And there are various reasons why individuals decide to use a trust versus a will. For instance, with a trust, you avoid the probate process, and the probate process is mandatory. It's an administrative process if you have a will. And if you don't have a will and you have a trust, you're completely bypassing that process. And it typically takes about 6 months to a year in Maryland, could take longer. But by using a trust, upon your passing, instead of going to the court and filing a probate matter, your trustee will take control of your assets and distribute them in accordance with what your trust dictates. Another reason why individuals use a trust is if they have property located not only in the state of Maryland, but in another state. If they don't have a trust and they have a will instead, they will not only have to open a probate matter in the state of Maryland, but they'll have to open what's called an ancillary probate proceeding in another state and essentially duplicate the process in both places. And so using a trust completely bypasses that process. And another reason why individuals prefer a trust is because of privacy concerns. The trust will never get filed in the court. It will never be a public record, as opposed to a will, which will be. Some
people, when they're thinking about their estate, are more concerned about taxes, owing them after their death. What are ways you can owe tax, and does that always happen when you die?
Certainly. I'm going to highlight 3 taxes because there are several that could be imposed upon your death. There is a federal estate tax. There's a Maryland estate tax. There's also a Maryland inheritance tax. And so I'll start with the federal estate tax. And that tax is imposed on your taxable estate at death. And it's based on the taxable estate, which is defined as your gross estate. That gross estate includes both probate and non-probate assets, minus certain deductions. And based on the year that you die, there is an exemption amount for that year. And so, for instance, if you died in 2016 and the value of your taxable estate, minus certain deductions, does not exceed $5.45 million, then there is no federal estate tax imposed. If it is imposed, then that range for the tax rate is 16% to 40%. But for most people, it's not a concern.
Yeah, sure.
With regards to the Maryland estate tax, that is a state transfer tax that is imposed upon the transfer of property at death. And that tax also has an applicable exemption amount depending on the year. And for 2016, that amount of the exemption is $2 million. And so the tax does not come into play unless your taxable estate is valued at more than $2 million. And that amount changes on a yearly basis. There's also the Maryland inheritance tax, which is imposed upon the receipt of property at death, and that rate is 10%. But it doesn't apply to everyone. There are certain exempt parties. For instance, a spouse of the decedent is exempt, as well as children of the decedent, parents of the decedent, grandparents. But a niece or a nephew that inherits, or a friend, they're not going to be exempt, and they're going to be responsible for that tax.
So that sounds like there could be some catches or nuances to be aware of. All right, and then you do another area of law, special needs planning or family law. Talk a little bit about that.
That is correct. And so there are certain circumstances where there are specific trusts designed to protect individuals in the estate planning process. And the special needs trust what it essentially does is it transfers property to a trustee to hold for the benefit of a disabled individual or an individual who's blind, essentially so that they can still qualify for medical assistance. Mm-hmm. And as long as you meet the requirements in implementing that trust, then you will not be disqualified.
Fantastic. Mm-hmm. Well, thanks a lot for the information. We appreciate it. The viewers do as well. Is there a website you want to give out?
There is. The law firm of Joseph Greenwald and Lake website is www.jgllaw.com.
Fantastic.
Thank you, Brian.
Sure. You're watching Your Future, Your Finances. We're going to take a break.